computer. Hello and welcome back. This is Roger Royce, host of the 10,000 Startups podcast. And today we are back again with Phil Elbert. He is an IP lawyer and one of my partners with Haynes Boone in San Francisco. As you know, I'm with Haynes Boone in Palo Alto, California. And today's topic is topical, it's timely, it's interesting. It's about AI chatbots and all the trouble you can get into over AI chatbots, because there's been a recent case in Canada, but I think it's still relevant for today, that Phil has written about and is going to tell us about. So Phil, thanks for coming back and tell me about the case. What is the case?
Well, Air Canada had an AI chat bot that they provided access to through their website, and somebody used that in buying a ticket, and it turned out that the AI chat bot gave advice that Air Canada didn't want to stand by. And so the litigation was, is Air Canada responsible for a deal that the AI chatbot offered to the customer and the customer took?
Okay, so the question is, are you responsible if your chatbot gives a wrong answer? So before we answer that question, maybe it'd be helpful to have a little bit more of the facts around the case, how to come up.
Well, it turns out that Mr. Moffatt, who's the plaintiff in this case, he went onto their website to secure a fare to visit his recently deceased grandmother, and use their Air Canada's bereavement fare to book the flight. And the chatbot explained to him that as long as he applied for the difference between the last minute full fare and the bereavement fare, as long as he applied within 90 days of booking the ticket, he would get a refund. Now, Air Canada says, nope, the rule is that you have to apply for it before you take the flight. And he did all that, did all the applications within the 90 days, and Air Canada said, nope, that's not the case because you've already taken the flight. Interestingly enough, Mr. Moffatt preserved screenshots of all of the chatbot answers, so there was no factual dispute about what the chatbot said. But what makes it interesting is that Air Canada said, now, we're not responsible for offers and mistakes that the AI chatbot made.
And so how much was in dispute here?
It's surprisingly that it's a small amount. It's maybe $800. And what's surprising about that amount is, I mean, it's typical for a small claims court or the counterpart in Canada, which is a civil resolution tribunal, is that a company would risk bad press when they're trying to encourage adoption of their AI and their chatbots.
Yeah. Okay, so what exactly then is the claim? We admit that it made a mistake. We admit that it cost, I guess, this guy some money. But what's the claim that is being made against the owner of the chat box?
Is that it was negligent representation, and that in reliance of the what the chatbot promised the rules would be, he purchased a ticket and did not get the promised refund.
Okay, so it's negligent misrepresentation, meaning Air Canada failed to do something that a reasonable person would have done, right?
Yes. Now, to be fair, on some other page somewhere on their website, they had the rules that Air Canada is sticking by, that the action needed to be taken before the flight was completed. But the question there is, can a customer be held responsible for checking an entire company's website to make sure that it's all consistent.
All right. And what was Air Canada's defense to this?
Well, surprisingly, one of the arguments that the court noted that Air Canada made is that the chatbot is a separate legal entity, and therefore, Air Canada is not responsible for a mistake or misrepresentation or a promise or an offer that the chatbot might have made.
Yeah, that is kind of a surprising assertion, isn't it? We set up this basically what is a software product and then say, look, it's got a mind of its own. We can't be responsible for that thing. I guess that's basically what they're saying, huh?
Yes, and so I think one of the things to learn from this is if you have a customer-facing chatbot or AI, you're responsible for what it says. Maybe it makes more sense to have your chatbot be a guide, and as users interact with it, the chatbot points the person to the applicable web page, as opposed to the chatbot trying to explain some complicated rule that maybe the chatbot might have just hallucinated.
Might have hallucinated. Yeah, that is a word of warning because I've heard that AI can hallucinate. I mean, we've heard about some famous and sometimes kind of funny cases, like the person who used the generative AI to give her an itinerary for an Italian vacation, and it came up with a totally fictitious place that she tried to book tickets to. So AI will do that, at least in these early days. You know what I find interesting about this discussion is that there's still got to be a negligence standard in there. It's not like strict liability. It's not like you guarantee everything the chatbot says, right? It said it was a negligent misrepresentation. So that means negligence, reliance, and damages. I guess that gives us a little bit of comfort if you're the company with using chatbots, right?
I think it does. It does say that if it's something kind of totally unforeseeable, and if, for example, if the chatbot had promised him that he could have a ride into outer space for a few $100s, that would clearly be totally unexpected that a chatbot would promise something like that. But maybe it could be held to a negligence standard if a chatbot does something totally unpredictable. But giving customer the rules and requirements seems like a straightforward thing that you could expect that a well-constrained chatbot would put out.
Yeah, well, that's fair. Now, what about the fact that this all happened up north of the border, up in Canada? Do you still place some weight on this case here in the United States?
It's of course Canadian law and Canadian courts is not binding on the US, and it's probably not binding in provinces very far away from British Columbia, but it's something that companies can learn from. Is let's not get into this situation.
Well, let's talk about that. What are the lessons from this case?
Is that maybe limit your chat bots, at least the ones that are customer facing, that could be a part of a transaction. Limit them to what they're really, really good at. Is maybe finding directions to give to a user to where they can find more detailed information. The other thing I think you learn from this is don't throw your chat bot out the window. You're gonna have everyone questioning whether they can rely on the chat bot, and they'll just bypass.
Okay. Okay, any other lessons?
Well, I'm impressed that that the plaintiff here got everything in writing. So that's one thing to, keep in mind. If you're dealing with a chat bot and you ask it a question and it gives you an answer, well, a few days from now, it could give you a different answer because it's learning as it goes. So there's not that definitive repeatability. So if you have a question about what the chatbot's doing, document it at the time.
Okay. All right. Well, those are good lessons to learn. So let me ask. I think this is a little bit different issue with AI than the ones we've talked about here before. This has to do with responsibility for what the AI says. And this is an area I think it's probably evolving. We're probably going to have to wait and see. I guess it's a negligence standard, though, is what I'm getting out of this case. I think that's what courts in the US would do. They'd apply a negligence standard. What about the IP issues here? Because you are an IP lawyer. And this stuff that the chatbot's turning out, I'm going to ask you because I ask everybody this. Can we protect that in any way?
I think if it's straight facts, maybe not. If it says, hey, this is the weather that is currently outside, that's kind of a fact. But if the AI is going to present a poem, then that would be protectable by IP.
Okay, I got you. And what about infringement issues? What if the chat box went and it answered the question by cutting and pasting somebody's copyrighted information? Do you think the owner of the chat box would have liability there?
I believe it very, very likely would be, because that's unauthorized copying. And that goes back to my earlier point, is keep your chat bot doing what it's good at. If it needs to cut and paste and present to an end user some information, cut and paste from the company's own website or documentation, not somebody else's.
Okay. That's good advice. Use your own data, like companies tend to be going. Okay. Anything else, Phil, we should know about this case?
No, that's
we covered it.
Good.
Is that subject to appeal? Do you think we'll hear more about it? Because there is, after all, $800 in dispute.
I think at some point, some wise counsel might have already said, okay, time to stop.
Okay, well, bummer. I'd kind of like to see how the appellate courts would deal with it. But we'll wait until the next time a chatbot screws up. Okay, well, thanks again, Phil Elbert, IP partner with Haynes Boone, San Francisco. This is Roger Royce with the 10,000 Startups podcast. We'll see you next week.